Hey, everybody. Here is the recording for the quote New Deal lecture. This is how all of the theories of Lochner come crashing down. So today's topic, again, it's the end of Lochner. And how does that happen? This is still the biggest story of the Constitution for really the 20th century. We still talk about it a lot, and understanding why the Lochner era theories are repudiated is a big part of understanding how legal change occurs and why we approach the Constitution the way we do now. So the biggest trend is obviously reversing the most controversial parts of Lochner. And the Lochner era, as we've said a number of times, is defined really by two things. The first is viewing the scope of federal powers narrowly. Again, we talked about the fact that the court says to Congress, you can't use your Commerce Clause power for that, or you can't use your taxing clause power for that. Second big thing that defines the Lochner era is reading into the Constitution this right to contract. Again, it's an unenumerated, meaning it's not written down anywhere, right? And the court protects that right. Those are the two things that define the Lochner era, and those are the two things that end at the demise of the Lochner era. So what do we see here on the screen? We see that during the Lochner era, again, the E.C. Knight case, the Dagenhart case, we see the court espousing this skeptical type of review. Congress's powers are viewed narrowly, and we're really concerned about this unenumerated right to contract. That is true both for Congress's use of its powers. We see that here in the kind of yellowish column, but also laws that abridge the unenumerated freedom of contract, as we've also been discussing. That's kind of the second part of Lochner. Let's look at how this changes. Again, it's really reversing that judicial skepticism and moving back to a deferential approach when it comes to judicial review, at least of this. So let's remember, let's put kind of a star or caveat in our notes that what we're doing is reverting back to a deferential type of judicial review for two things: for a consideration of whether or not Congress properly used its enumerated powers, Commerce Clause, Taxing Clause. We're going to talk about the Spending Clause. And two, laws that might abridge the unenumerated freedom to contract. We say that's no longer constitutionally protected and/or at the most subject to a type of deferential rational basis review. What we're going to see later in the course is that there are spaces, there are times when judges say we need to use a skeptical type of review. And that is really the question for us as we move forward in the course: is when does that happen? When does the court say, now we have to be very aggressive? And for instance, we have to look at why a state took the action that it did as we move forward. What is happening in America at this time? Elections, and Democrats are taking over the elected branches. We can see that on the screen very clearly as we move from the left side to the right side. With the elections of 1932 and 1936, we see Democrats dominating the congressional branch, the legislative branch, and also the presidency. What do we not see becoming blue? Obviously, it's the courts, because federal judges have lifetime appointment. And as we have talked about before, that's for a reason. That's to make sure that they're not subject to political winds, but it does create tension. And particularly it creates tension when you have a president like Franklin Delano Roosevelt, who's trying to change our system of government and create these big, bold pieces of legislation. So what we see here is FDR wants to implement his New Deal vision for the country. And we see he's carrying New Deal remedies, and Congress is behind him, and the judiciary keeps stopping him. This is the era when we invented Social Security, agricultural subsidies, and much, much more. So what we see here is the president really having enormous amount of tension with the Supreme Court, the umpire, because the Supreme Court is striking down a bunch of these big new government programs for the usual Lochner era reasons. Again, what are the usual Lochner era reasons? Congress doesn't have the power, and or Congress or states are abridging the freedom of contract. So think about things that the Supreme Court struck down. We can see them in that red box there: the National Recovery Act, the Agricultural Adjustment Act, many more acts. And it's creating this really significant tension in our society. In 1936, FDR's reelection campaign is based in part on criticizing the Supreme Court and really trying to run against the Supreme Court. And we see here, it's not just FDR. There are lots of people objecting to what the court's doing. There are newspaper editorials, there are law review articles, there's dissents on the Supreme Court, there are lower court judges, there are state court judges, state lawmakers. Ultimately, there is a plan that's floated to pack the court, to increase the number of justices on the court by changing the composition of the court, change the court's decisions. Now, Congress never acted on this court packing plan, in part because the court kind of responds and says, okay, we'll go ahead and change course. So there's an enormous amount of pressure on the Supreme Court, and the Supreme Court ultimately kind of decides, we're going to change what we do here. So the court packing plan, it introduces very high drama. And in another type of course, we would spend more time talking about that. And of course, there are some members of Congress that are openly mulling that idea today. But the idea never comes to fruition because we see the court changing tact. Again, what does changing tact mean? It means reversing what happened during the Lochner era. We've been talking about this before, but I want to make it clear: the freedom of contract is constitutionally protected as a liberty under the 14th Amendment or the Fifth Amendment Due Process Clause. No longer. We move in 1937 to Parrish. The freedom of contract is not constitutionally protected. Labor laws are not a legitimate use of states' police power. We saw that in the Lochner case. No longer. Labor laws are a legitimate use of a state's police power. Finally, C, courts should carefully scrutinize what lawmakers' motivation really is. No longer. If Congress, for instance, has the power under the Commerce Clause to implement a piece of regulation, then that's that. We don't look behind to see what is Congress really trying to do here. That brings us to West Coast Hotel versus Parrish, and a quick summary of what's going on in this case. Under Washington state law, there's a minimum wage of $14.50 for each work week of 48 hours. Elsie Parrish is an employee of the place we see right here, the West Coast Hotel Company. She receives less than the state minimum wage. So she sues the hotel and she says, you owe me money. You owe me the difference between the wages that you paid me and the minimum wage that was set by state law. Now, the lower court in this case rules against her, in part because the precedent is against her. There's a 1923 Supreme Court decision called the Adkins case. It's Adkins versus Children's Hospital. I'll talk about it more in a moment. And there, the court struck down a minimum wage law for working women. Here, in a 5-4 decision, the Supreme Court reverses itself. It upholds the state minimum wage law, and it says that the law did not violate the 14th Amendment Due Process Clause. This is the end of the court's broad view of the freedom to contract, and it's really seen as the end of the Lochner era as well. Now, I just mentioned the Adkins case. I don't want to go through this slide in too much detail, but I want to highlight a couple of things because I think it helps us realize how constitutional change occurs. What we have here is in 1923, let's skip ahead to number 3, 1923. In 1923, the Supreme Court decides the Adkins case, comes down with the Adkins case. It's under the Fifth Amendment because we're talking about DC as opposed to states. And the court says this DC minimum wage law for women, it's not constitutional for, again, all the Lochner era reasons. What happens in this case, in the Parrish case? The Parrish case, it goes before the state trial court. Now we're on the left side of the screen, number 4. And the state trial court says, we've got to strike down this law. Adkins controls. Then something happens. The Washington Supreme Court, again, the state Supreme Court in 1936 says Adkins doesn't control us, mainly because they say Adkins is wrong. And this is really an act of civil disobedience. We know based on the Supremacy Clause that state court judges have to follow federal law. And they can't say, we don't agree with that Supreme Court decision, when the Supreme Court decision obviously affects the question that they're answering. Here, our question is, here we have a state Supreme Court, it's rejecting the Supreme Court's decision, and it insists that the dissent in the Supreme Court case was actually correct. So what is the Washington State Supreme Court trying to do here? They're trying to change the law. They don't like what the US Supreme Court did. So maybe they're hoping that the Supreme Court would just choose not to review the case, not to grant certiorari, and just to leave that state Supreme Court decision as is. Or maybe they think they want the Supreme Court to take the case and reverse itself, which of course is ultimately what happens here. One thing I want us to consider for a moment is it improper for the Washington Supreme Court to enforce a law that was substantially similar to the one that was found unconstitutional in Adkins? Meaning, is it appropriate for the Washington Supreme Court to basically ignore controlling US Supreme Court precedent? On the one hand, we can say, well, it forces a dialogue and reconsideration of the US Supreme Court decision. And it can give the US Supreme Court a signal that there's a problem with its decisions. On the other hand, that's not the way our legal system works, right? We have a supremacy clause. State Supreme Courts are supposed to follow US Supreme Court precedent. And it's messy and time consuming when state Supreme Courts don't fall in line. But in this case, the Washington Supreme Court's tact was successful, right? What happens here is the Supreme Court overrules Adkins, and this is the first judicial overruling that we've seen. And I want to talk about that in a little bit more detail, but we saw there was a conversation before between the legislative branch and the Supreme Court when it came to the Reconstruction Amendments. And we talked about how those Reconstruction Amendments were largely a response to Supreme Court decisions. But here we have the Supreme Court just saying, we got it wrong. And our approach to these questions was wrong. The court does not do this lightly. Obviously, we are seeing more precedent that's being overturned right now, but it is still supposed to be a rare occurrence. Now, why? Because of the benefits of following precedent: consistency, predictability, the idea that the development of the law is about more than just who is on the court at any given time. And typically there needs to be really powerful reasons for overturning earlier precedent. Now, what do we see here in the Parrish case? Now, which one of these are good reasons to overturn precedent? Well, the first one, the importance of the question. So we're asking really, does this case address a particularly important question? Then maybe we should be more likely to overturn precedent because it's really important that we get it right. So we don't just want to say, well, we already decided this and we have to rely on our old decision. If it's a really big, important decision, maybe we should be more likely to overturn to make sure that we get something right. Was the old case closely decided? Maybe if it's a 5-4 decision, we don't owe it as much deference. In this case, that third bullet point is economic conditions. Have economic conditions changed? But more broadly, we really ask, are there any changed conditions? Then maybe there are reasons to reevaluate the old case. One other thing I want to point out here is that this is really seen as the key part of the Parrish case. And what we have here is the court saying the Constitution does not speak of the freedom of contract. It speaks of liberty, meaning that word liberty in the 14th Amendment and the Fifth Amendment due process clauses. It prohibits the deprivation of liberty without due process. But again, there is nothing written in the Constitution that talks about the freedom of contract. This is really, as I said, the central passage of Parrish. And it's an acceptance of a dissent that we saw very recently. It's an acceptance of Holmes's dissent in Lochner. And they're repudiating the view that the Constitution protects this freedom to contract. The court's really saying here, if our old decisions, if our precedents deviate from the text of the Constitution, that's a good reason to overturn precedent. What I want to mention here is this is very similar to the reasoning we see in the Dobbs decision that overruled Roe v. Wade. Next point that I want to focus on is constitutional structure and judicial review. I started this lecture by talking about the fact that during Lochner, again, judges have this very skeptical type of review that they're employing. At the repudiation of Lochner, after the repudiation, we're really using a more deferential type of review. And we see that here. We see here the court specifically saying we're cognizant of separation of powers, meaning judges overstepping and going into the legislature's lane, so to speak. Specifically, we're worried about the need for the judiciary to defer to the legislative branch. That's what we see in the quote. And again, what we're doing is we're ushering in a new era of legislative deference. Another thing that I want to focus on here is this idea of what is the liberty that we're worried about? What is the liberty that we're protecting in these cases? Because Lochner has one view of the liberty that we're protecting, and Parrish has a very different view of the liberty we're protecting. The same is true for Adkins, that Lochner era decision. Adkins and Lochner have a very similar view of the liberty that we're protecting, whereas in Parrish, we see the new view, a different view. Nobody wants to be anti-liberty. Judges, political actors, everybody wants to cast themselves as being pro-liberty because that's a good way to gain support and respect. But there's no hard and fast definition for what being, quote, pro-liberty really means. So let's talk about the Adkins case first in terms of who are the villains, who are the heroes. In Adkins, the villains are lawmakers who are overregulating us and burdening the freedom to contract. We've talked before about how during the Lochner era, regulation is viewed with suspicion. The hero in Adkins are the judges who are protecting our liberty by using this aggressive type of judicial review and maximizing our freedom from government regulation. The idea that government regulation is a bad, freedom from government regulation is a good thing. The villain in Parrish, by contrast, greedy private employers. And here the idea is you really aren't free if you're working in a sweatshop. You're not free if you're working for poverty level wages. This sounds like Harlan's dissent from the E.C. Knight case. He argued that people have a right not to be manipulated by private monopolies. So again, Parrish is going back to the dissents in the Lochner era. Now, the hero in Parrish, it's lawmakers. It's lawmakers and the political branches in general who are trying to protect our liberty, meaning save less fortunate people from sweatshop conditions. Again, two very different views of the liberty that we're worried about, the liberty that we are trying to protect. So we left off talking about the Parrish case, and that case deals with estate law and dismantling of the constitutional protection for the right to contract. Now, let's move on and talk about how the second part of Lochner crumbles, how the court's interpretation of Congress's use of its enumerated power, and we're going to focus on the Commerce Clause, changes, meaning how the court goes from saying, Congress, you have really small power when it comes to Commerce Clause, taxing clause, spending, to Congress, you have really big power, and we're basically going to go from being skeptical to being deferential. Have you heard me say this before? Absolutely. I know that I am repeating myself. I want us to be clear on exactly what Lochner stands for and what changed. So, three types of commerce up here on the screen. We've also seen this slide before. Cross-border transactions, we've talked about those, the infrastructure to facilitate cross-border transactions, and then, of course, the most controversial one, and the one where, therefore, there's the most litigation, which is in-state activities with a substantial effect on interstate commerce. This idea, as we've talked about, was first floated, no pun intended, in the Gibbons case. And there the court talked about some in-state transactions that affect other states. With the New Deal, the federal government wants to be more active in regulating the economy. They want to break up monopolies. They want to create minimum wage laws, maximum hour laws, all of those types of economic protections for workers that we've been talking about. And this requires that Congress be able to rely on this third bucket, and that the court lets Congress rely on this third bucket. Very similar to what we saw with respect to the freedom of contract and how that was protected, and it no longer is. We see the change from the Lochner era cases where some conduct, we're starting with A, some conduct is seen as just local, to no conduct is just local. We have to consider whether that conduct as part of a larger set of economic transactions actually has a substantial effect on interstate commerce. In B, we have a very narrow set or isolated view of what economic transactions are during the Lochner era. We move over to the right column and see that economic activities and their effects are seen as linked and aggregated. We'll talk about the Farmer-Filburn case. We, as I've mentioned to you before, we abandoned the direct versus indirect test, and we just look at substantial effects. And again, we move from saying we need to look at Congress's motives, and if Congress is really trying to do something like, for instance, limit child labor, that's not okay, to saying we don't care about Congress's motives. We just need to see if Congress has this power under, in this case, the Commerce Clause. So the 10th Amendment is not seen as the type of limit on federal power once we dismantle Lochner as it was during the Lochner era. Okay, let's talk about the cases that were overruled. So the E.C. Knight case was the case involving sugar refineries in Pennsylvania. There, we talked about the federal statute was the Sherman Antitrust Act, and the statute says no monopolies. The Department of Justice brings a suit to block a monopoly ownership of national sugar manufacturing. And the court says manufacturing is not interstate commerce, and so the federal government can't regulate it. It precedes commerce, but it is not itself commerce. Now, what happens is that case is overruled. What we also get rid of is this very isolated view of commerce, as I said, that ignores the fact that to manufacture sugar, you typically need supplies from one state, and the sugar will typically be sent to another state. So all along the way, before the manufacturing, after the manufacturing, we see that interstate commerce is in fact involved. Let's talk more specifics about this New Deal view of the Commerce Clause. So meaning, how do we overrule the court's limited view of Congress's Commerce Clause authority in the E.C. Knight case that we've just been talking about? The answer is the NLRB case, Jones and Laughlin Steel. So 1935, Congress passes the National Labor Relations Act. This is a statute that is still on the books today. It includes the creation of the National Labor Relations Board to enforce the statute. Just like for those of you who are familiar with the Federal Election Campaign Act, it includes the creation of the FEC, the commission that oversees and enforces the act. So the NLRB, the board, charges Jones and Laughlin Steel, the country's fourth largest steel producer, with violating the federal statute because it discriminated against employees who were union members. And part of what the statute said is you can't discriminate against employees who are union members. That's part of the NLRB. It was then, it is now. The court concludes that Congress does have the power to pass the National Labor Relations Act because it's regulating industrial activities and it has the power to restrict interstate commerce. Those industrial activities could affect interstate commerce and therefore they can be regulated. That's the cleanest and most simplest way of putting this. So in general, the court says here, Congress, go ahead and use your Commerce Clause power, use that authority to regulate any activity with direct or indirect. Again, we get rid of that direct/indirect comparison that we were focusing on during the Lochner era. And we say here, as long as the activity has either a direct or indirect, but significant, sometimes phrased as substantial, significant or substantial effect on interstate commerce. That's what we care about. Do you have a substantial effect on interstate commerce? Sometimes phrased as, do you have a significant effect on interstate commerce? If yes, then Congress go ahead and regulate that activity. Here the court says, and we see this up on the screen, of course, a manufacturing plant is part of interstate commerce, and therefore, of course, Congress can regulate it. In this case, what we have is a manufacturing plant that is a functioning part of a nationwide network for steel. Again, this sees commerce as a set of transactions, unlike the E.C. Knight case, where everything is broken up into these isolated, discrete parts. So parts of the network are within the state, but they have such a, as the court says, close and substantial relationship to interstate commerce that government control is essential or appropriate to protect commerce. The court here says the same thing about relationships between labor and management, that even though you may not have a direct impact on the flow of goods, they have an aggregate and therefore substantial impact on the flow of goods. What do we mean by this? Specifically, what we mean is if there's a situation where there's a conflict between labor and management, meaning a labor management dispute, maybe a strike, in that case, there could be an at least temporary end to manufacturing, and that could potentially impede interstate commerce. And therefore, Congress has the power to regulate and control labor management issues. So having concluded that Congress has the power to pass the law, the court says under the law, it says companies don't discriminate against employees for exercising the right to create or join a union. Now, pause for a moment. Given all this, the big question under the modern Commerce Clause cases, very, very typically, in what way does Congress's law regulate something that has a substantial effect on interstate commerce? Meaning, let's go back a few slides, that our big legal question when it comes to the Commerce Clause is this: how big is Category 3? how many things fall within category 3? And the answer is, for a while, it looks really big. As I mentioned on the first day of class, it looks like maybe then it contracted a bit in the 1990s. We'll talk about whether or not it really did. And then we have to discuss where we are today, of course. So in this case, what happens? The law in Jones and Laughlin involves employment conditions, specifically a company that interfered with workers' ability to form a union, join a union, all of which relates to wages, hours, working conditions. All of that affects interstate commerce. So Congress go ahead and regulate it. And that is the punchline for the NLRB case here. I want to make sure we're really clear on the shift and exactly what is going on in the case. So how do Jones and Laughlin Steel's employment practices affect interstate commerce? I said it before, I just want to say it again. If workers go on strike, that is seen as affecting and bad for interstate commerce. We're going to talk about this when we talk about President Truman's seizure of steel plants during the Korean War. 2, workers' wages affect the price of finished goods, which itself can be seen as affecting interstate commerce. And of course, number 3, there's the potential for unfair competition, where non-union states have a price advantage over union states. So that's what I want us to take away from the NLRB case. Let's talk about our next overruled case. E.C. Knight was overruled. We talked about NLRB. Now Hammer versus Dagenhart will be overruled, and we'll talk about Darby. So Dagenhart, again, I've mentioned this statute a number of times. The congressional statute says what? There can be no interstate shipment of goods made with child labor. And we talked about the fact that Congress wrote it that way because they didn't think they had the power to just say no child labor. They thought they had to hook it to interstate commerce, but the court still said no. Remember the old logic there. Manufacturing is not commerce, as we see on the screen, so the government can't regulate it, even if the regulation involves interstate commerce and cross-border transactions. Now, new view, US versus Darby. So it's 1938, Congress passes the Fair Labor Standards Act to regulate many aspects of employment. Again, 3 years earlier, we see Congress passing the National Labor Relations Act. We see Congress focusing on these areas as part of the New Deal era. Here, we're focusing on many aspects of employment, including minimum wages, maximum weekly hours, and child labor. And we're focused on 2 parts of the statute here. You see it on the screen. No interstate shipment of goods made with low-wage labor. And the statute defines exactly what that is. Manufacturers must abide by specific federal wage and hour laws. So the law regulates, as we see in yellow number 1, the law is very clearly regulating cross-border transactions, like the one in Hammer versus Dagenhart. And Congress is basically giving it another go with the court and saying, how about now? Will this work for you now? And the answer is yes. So Darby is a lumber manufacturer and ships lumber out of state and was arrested for violating the Fair Labor Standards Act. How do the wage and hour restrictions on Darby's factory affect interstate commerce? I know this seems obvious, but if you sell across state lines, the statute says you must pay minimum wages and have maximum hours. So we're talking about production for interstate commerce. And the court concludes, yes, Congress, go ahead and use your Commerce Clause authority to enact this statute. Congress's goal was to outlaw states from allowing substandard labor practices, to prevent private industry from allowing substandard labor practices. And substandard labor practices, as we've talked about, have an significant, substantial impact on interstate commerce. That's what we need. That's the hook we need to say, you can use your Commerce Clause authority. Fun side note, the court goes all the way back to the Ogden case, the New York Ferry case, as a key precedent. So what's our logic here? The federal government can regulate in-state manufacturing when it substantially affects interstate commerce, and here it does. The government argued here that it wanted to prevent certain goods from traveling in interstate commerce. Is that just a pretext for trying to conceal their real purpose here, which is just to raise local wages? Probably. Probably, yes. Probably that is a pretext. And it's likely not the case that the boards that are milled by underpaid workers are inherently more dangerous than those that are milled by better paid workers. But we don't care about congressional motive here. And notice the distance we're traveling from that logic in Hammer versus Dagenhart to the logic here. In that case, again, the court's really offended by the fact that Congress has a true motive to try and end child labor. Here, Congress might have other motives, but that's okay as long as whatever they're regulating has a substantial effect on interstate commerce. Darby on Lochner era misconceptions about the Commerce Clause. So in this passage, what we really see is the Darby court just knocking down piece by piece what they view as misconceptions that were seen in earlier cases, especially the Hammer versus Dagenhart case. Again, big one here that we're looking at, we don't care what Congress was really thinking. We don't care if Congress is giving us a pretext reason, as long as it has that power. Motive no longer matters. It doesn't matter if the federal statute has in-state consequences, as long as it has a substantial effect on interstate commerce. It doesn't matter if the federal statute kind of looks like a law that could be enacted by the states under their police powers. The fact that it looks or smells kind of state-like, that's okay. What does matter? What matters is whether or not the federal law regulating something, as we've said, has a substantial effect on the nationwide economy. And you can find the language that gives us the seeds of this ruling back in the Gibbons case. So there we go here. Motive doesn't matter. In-state consequences don't matter as long as you have a substantial effect on interstate commerce. And even though this statute maybe looks like something that a state would typically pass, that's okay as long as Congress has the power. What does all of this mean? It means that as the federal power gets bigger and the federal government can regulate in more areas, where do we see the contraction? In the state power. And after Darby, what can a lumber mill owner do to avoid federal regulation? We just talked about federal regulation getting bigger. To avoid, in this case, to avoid the law, don't sell anything across state boundaries. Don't sell anything across the border. But something to consider as we're talking about our next case here is maybe there are some federal statutes, there's some federal power that can reach even industries where the product never leaves the state and never will leave the state. So let's move on to Farmer Filburn. A 1942 case. What do we notice right off the bat about Farmer Filburn? Jones and Laughlin Steel, our prior case, involves a huge, for the time, multi-state corporation with factories in lots of different states. Darby involves a single factory in a single state, but one that makes goods that are sold in interstate commerce. Those are easier cases to say Congress has the power to regulate these particular companies or this particular industry. But does Congress have a federal power that reaches even a small in-state operation like Roscoe Filburn? And the answer is yes. And this is an important case for us to understand. So here's Farmer Filburn. He's posing for a photo. And let's talk about briefly, because this is not my specialty, but let's talk about the economics of farming. Let's talk about some high-level concepts here. So if you plant more land to grow bigger crops, you tend to make more money. And that's fine when there is demand. But if you keep planting more land and you end up overproducing, then you have too much product. The surplus is greater than the demand. And so we're having a problem with our supply and demand curves here. The bigger surplus as compared to a smaller demand mean that the prices are going to go down. And then what does that make farmers want to do? It makes them want to plant even more and try and increase the volume to somehow get to the same amount of money that they were making before. But that ends up just driving prices lower because you're flooding the market with too much supply. Congress is worried about this at the time, and they're worried about, without going into too much detail, an economic catastrophe. There are farmers that are not able to make ends meet. There's huge instability at the time. There's the possibility of a number of different farmers just leaving the market. And there's very real concerns about a catastrophic food shortage. All of which is to say, at the time, Congress has a very real interest in smoothing out the supply and demand curves when it comes to the supply of food. What we see here is, and the statutory background that was edited out a bit, is that experts that are working for an executive agency, an administrative agency, set a quota for the amount of crops that farmers can sell. And Filburn, as I think is clear in the case, Filburn goes beyond his quota. Filburn is a small farmer in Ohio. He harvests nearly 12 acres above his wheat allotment. He harvests more than his federally approved quota. Where is that quota set? We're focused on the 1938 Agricultural Adjustment Act. What happens when you violate an act? If Congress finds out or somebody else finds out, you are penalized, and Farmer Filburn is. His argument here is that the extra wheat that he produced, even though it violated the federal law, it was just going to be used for his own purposes. He was just going to eat it. And therefore, it had no effect on interstate commerce because it was never going to be put on the market. He's saying, I harvested that wheat for me. I was never going to bring it to even a local farmer's market. Therefore, in his view, he actually didn't violate the law because the additional wheat was, in his view, not subject to congressional regulation under the Commerce Clause. He's saying this is not something that was ever going to be put into commerce. And a unanimous court said to Farmer Filburn, sorry, you're wrong. They said Congress has the power under the Commerce Clause to pass this act and to regulate this activity. Number one, do you have the power to pass the act in the first place? Number two, can the act apply to this activity? And the answer is yes, because Congress can regulate activity within a single state under the Commerce Clause, even if each individual activity has really a trivial effect on interstate commerce. There's no question that Farmer Filburn on his own has a deeply trivial effect on interstate commerce. We add up, we aggregate every Farmer Filburn and ask if that would have a substantial effect on interstate commerce. Meaning, what if every small farmer went above their allotment? Maybe if they're growing their own wheat, then they're not going out to buy wheat, and that's hurting demand even more, for instance. So it's not Farmer Filburn affecting interstate commerce, it's every small farmer across the country. Add them all up, does that affect interstate commerce? And the answer is yes. A couple of more details. We know from Jones and Laughlin Steel, and we know from Darby, that if Farmer Filburn had been growing food that gets exported out of state, that's subject to federal regulation because his production is for interstate distribution. Again, in this case, I know I've said it before, it's not going anywhere. The wheat isn't even going to the local farmer's market. Filburn is a small farmer. He's just one little individual. So why can the government control what Farmer Filburn is doing? Because what the government's doing here is controlling the interstate market for this commodity. In this case, it's wheat. The supply side, and in fact, the demand side, is made up of all of these little decisions that individuals make. And so, as I said, if each small producer is added up, that has a substantial effect on interstate commerce and therefore on the price of wheat. It doesn't matter if that impact is, quote, indirect. What matters is add every Farmer Filburn up, and that in the aggregate has a substantial or significant effect on interstate commerce. That's going to have nationwide effects on crops that will affect the interstate market for that commodity, for wheat. Specifically here, what effects, we've mentioned some of them, but what effects would Farmer Filburn harvesting more than his quota have on interstate commerce? Because again, he's never going to sell the wheat. Limiting what Filburn and everybody else can grow is a way to regulate supply. That's pretty straightforward. You can't grow as much, therefore you can't supply as much. Another one that I mentioned, if you are deciding to grow your own food, then you're not going out to buy anybody else's food, and you're reducing overall demand within this market, and that further depresses prices. Now, at the end of the Darby case, I said to you, is there a way for Mr. Darby, our Georgia lumber mill owner, to avoid the federal law? And the answer was yes, just don't sell out of state. But is there a way for Farmer Filburn to avoid federal Commerce Clause power after this case? I think the answer is really, really hard to find that. We see here that unlike during the Lochner era, where legislative branch is pulling in one direction, the executive branch is pulling in the same direction, but the judiciary, the court, keeps striking down all of these acts. We now see this famous cartoon, The Judge Has Caught the Step, and the Supreme Court has now changed tact. It's giving, as we keep saying, much more deference to Congress's judgments. And FDR, we see him here in the cartoon, FDR says all three horses, meaning all three branches of government, need to pull in the same direction, and now they are. I really want us to think about the next question. Should we be happy about that? Why bother having a separation of powers if one branch is duty-bound to defer to the others? And particularly coming up to what we're going to talk about next, what about individual rights? During the Lochner era, we had a law, we talked about at some length, that made it illegal to teach German. That was in Nebraska. Are courts supposed to fall in line with those types of laws? The results would be more decisions like Buck v. Bell. That was the involuntary sterilization case, where you're turning a blind eye to individuals. And you're basically saying, well, whatever the majority wants, whatever the political branches wanted. So that's the puzzle that we're going to be turning to next. When should the court defer to legislative judgment? And when should the court say, sorry, we need to step in and really second guess what you're doing here? All right, that is the end of the New Deal lecture. I'm going to go ahead and stop the share and stop the recording.